As a point of departure, my lord, our PO is the one dated today. I fully associate myself and I do adopt the submissions that have been made by my two colleagues. My lord, as though those were the submissions that I've already made in respect to my own application, my lord. That is mutatis mutandis. My lord, I will just delve on parts that they've not touched on. My lord, the point of procedure or the point of departure, the airport should be the Constitution, and my lord, Article 2, which talks about the supremacy of that Constitution, and specifically Article 2.2, which tells us about the authority that any organ exercises is pursuant to the Constitution. My lord, having said so, that is Article 2.2, my lord, I would also buttress that with Article 10, sub-Article 2A, my lord. A and B, my lord, which in essence indicates that there should be non-discrimination in any process that is being undertaken by any state organ or any state officer, including the courts, my lord. So the essence of this is to say that if there is a process that has been established by law, my lord, the tenets of Article 40, access to justice, Article 50, fair hearing, my lord, and Article 25 on the non-derogable right of fair hearing will extend to the process and even the forum within which a matter is heard affecting any person. So that, my lord, if for a certain individual, a separate process is initiated, separate from what has been defined in law to deal with any person in this country, my lord, that process will then fall short of the provisions of the articles that I've indicated. And that goes directly against the provisions of Article 25, the right to fair hearing, my lord. Even if Lucifer was to come here today, my lord, we will be bound to give him the right of hearing through the process that will be applied to the Archbishop of any church in this country, my lord. So to that extent, that is the point of departure. And my lord, the reason we say that, my colleagues have indicated from the Constitution, they've dealt with Article 162, which we are very clear in terms of the where jurisdiction of this court ought to emanate from. That is not debatable. My lord, I'll take it further in terms of Article 165, my lord. Article 165, which has created the High Court, and wherein the supervisory jurisdiction is clearly indicated under Article 165, sub-Article 6. And it tells us that the High Court has supervisory jurisdiction over subordinate courts and over any person, body, authority exercising a judicial or quasi-judicial function. So this is a very separate article that the framers of this Constitution indicated that we have already dealt with the ELC and ELRC and gave it a whole standing Article 162, indicated where jurisdiction flows. Thereafter, they went 3 articles after and created Article 165 and said now there will be this High Court, and indicated the powers of this High Court includes sub-Article 6, 165, which is very clear and which has been exercised ever since. My lord, to that particular extent, it is my humble view that the issue of jurisdiction, even in terms of the acts that are there, should start from the Constitution. Because any other law, like my colleague has indicated, which departs from the clear provisions of the Constitution, is null and void to that extent. So it is my view that as far as I am concerned, and when we look at Article 18(1)(b), it, in my view, it conforms because it has given that provision or the powers to the High Court specifically. And if there was any need or any challenge to that, it will have been amended, like the court is rightly saying, and we'll have seen that power being extended now to the ELRC or ELC, if that was ever a case in point. And we have had the law since 2012. Up to today, that has not been done. So we are then bound by the provisions of the Constitution that flows directly to Section 18(1)(b). But even as I look at Section 18(1)(b), my Lord, the order that brought this matter before the court, my Lord, that is, I refer to that order, my Lord, it indicates that the provisions that the court has quoted is Section 18(1)(b). That is what actually gave the court the powers to bring this matter here. And my Lord, I bothered myself to look at the provisions of 18(1)(b). My Lord, it says, the powers of the High Court to withdraw and transfer case instituted in subordinate courts. B tells us that one of those powers is to withdraw any suit or other proceeding pending in any court subordinate to it, and thereafter, 1, try or dispose of the same, or 2, transfer the same for trial or disposal to any court subordinate to it and competent to try and dispose the same, or lastly, retransfer the same for trial or disposal to the court from which it was withdrawn. So, my Lord, there is a settled position that any order, any law must be very clear. In fact, even us, when we are drafting our applications, we must be very clear under which provision are we moving the court. So the order of the court, I don't know if it was a typing error, does not tell us which was, is the court moving, or this matter, is the court bringing this matter under sub-article 1B, Roman 1, Roman 2, or Roman 3. That is not clear. So that a client who receives this order will not have the benefit of knowing, am I coming to this court for purposes of trial of the entire matter, for purposes of transfer of the matter to another court down there, if there was an issue with the magistrate that was dealing with it or the court, or am I coming back to this court for a retransfer? So to that extent, my Lord, the face value of the order does not talk about a contempt application in terms of a notice to any person who will receive it, even my client, because this is a matter that affects my client directly also. My client never knew, and in fact, that's why it has employed my services, because they are saying something is not right. And in my view, that is the view that I gave, that the provision that has been quoted does not tell us that the court can call this matter and deal now directly with a contempt application. And even if it was, my Lord, the right to be given a notice that you are coming to deal with a contempt application, which is as serious as they come, because it's akin to a criminal process. So that even this client would have had the right to know the nature of the advocate that will have represented him or her or the company in such a matter, because it appreciates the gravity of this matter at that stage. But again, this is all for naught, because it's still a power that can be exercised at the High Court and not this court, my Lord. My Lord, to a large extent, my Lord, I've majorly associated myself with the authorities that have been reigning, my Lord, but majorly they are speaking the same, and there is no disparity. But my Lord, I will deal with one authority which my colleague has not dealt with. I do apologize to the court that this authority is not with the court, because I just filed my application, but it is a reported case, my Lord, which I believe the court will have the benefit of getting, and I will place the same on record. It's actually already been filed. I've told my law firm to file it. But at the end of the day, my Lord, this is a locus classicus case from none other than the Supreme Court on such a matter. And my Lord, this is the matter of Republic versus Carissa, Chengo, and 2 others. My Lord, That is Supreme Court petition number 5 of 2015.
Yeah, I know about it. Actually, I'm the one certain that.
In Malindi, my lord. But now it is the Supreme Court decision on that once it was applied. And it was a very good job, my lord. Yes. And that's why the court knows all this. But my lord, just to support your position, my lord, the Supreme Court supported your position very well and indicated clearly the disparity. And I don't want to then read because the court is well appraised of it. But it clearly indicated that particular difference, that there's a difference between status and jurisdiction. Yes, this is a court that has the same status. It is not equivalent to say that the jurisdiction